Hi, I'm Mary Martin with an update on developments in Texas administrative law that may affect other administrative regulations. Texas prohibits alcohol manufacturers, wholesalers, and retailers from owning even a single share of one another's business. The Texas Association of Business has joined with McLane Co, a huge trucking company and food and drink distributor, to challenge Texas's one-share rule. The suit against the state challenges the one-share rule, arguing that it serves no perceptible government or societal interest of any kind. The lawsuit was filed in June of this year in federal court against the Texas Alcoholic Beverage Commission, also known as the TABC. Texas regulates alcohol drinks under a three-tier system: manufacturers, wholesalers, and retailers. A key principle of its alcoholic beverage code is that the three tiers operate independently of each other, so tied houses are illegal. According to the lawsuit, it is illegal for a person or business that operates in one tier to own even a single share of stock in a company that operates in another tier, even in the absence of any control or influence over the other company. Some have likened this system to prohibition because since the end of Prohibition, Texas has prevented huge corporations from selling retail hard liquor inside the state. The forces behind this lawsuit have a large interest in this decision. McLane, which runs 80 distribution centers across the United States and is one of the nation's largest trucking fleets, says it applied for a Texas alcohol wholesale permit, but the TABC rejected it because McLane's parent company, Berkshire Hathaway, owns about 2% of Walmart's stock. Walmart, under the TABC's reading of the code, is an alcohol retailer, and so McLane, if they're granted a permit, would be an alcohol wholesaler. Thus, the TABC determined that if it granted McLane's application, Berkshire Hathaway would then be in violation of the tied house provisions of the code because Berkshire Hathaway would own shares in both McLane, a would-be wholesaler, and Walmart, a retailer. On the other side, along with the TABC, is the Texas Package Stores Association, which is a group of TABC permitted liquor stores, in other words, smaller liquor stores. The Fifth Circuit recently ruled to allow the association to intervene after having been previously denied that right by the trial court. The association claims that they need to protect their own business model, as well as 80 years worth of law, which was originally intended to keep the mob out of the state of Texas. Of particular interest is a report that is cited in the plaintiff's federal court complaint. University of Texas economist Dr. William Charlton, Ph.D., examined overlapping ownership of companies that are involved in this three-tier system, as well as 4 Texas public pension funds: the Permanent University Fund, the Employee Retirement System of Texas, the Teacher Retirement System, and the Texas Permanent School Fund. All 4 funds held equity positions in companies licensed to manufacture alcoholic beverages by Texas, as well as companies licensed to retail alcoholic beverages by Texas, as well as companies that owned premises on which franchisees held licenses to retail alcoholic beverages, Charlton wrote in his report. Yet, the TABC has not applied its one-share rule to these Texas public pension funds or to the licensees in which the funds hold stock. If the TABC actually applied the one-share rule consistently across all licensees, few, if any, publicly traded companies would be able to manufacture, distribute, or retail alcoholic beverages in Texas. The outcome of this lawsuit may affect state pension funds as well as spill over into other areas such as legal ownership, law firm ownership. We will continue to keep you updated on the outcome.